Hi all, and welcome to this webinar on ACNC Director's Duties. My name is Kwan, a Senior Associate in Bartier Perry's Corporate and Commercial team. Before we begin, I would like to begin by acknowledging and paying my respects to the Gadigal people of the Eora Nation, the traditional custodians of the land on which we are broadcasting from today. I would also like to pay my respects to their elders, past, present, and emerging, and acknowledge all Aboriginal and Torres Strait Islanders joining us today. Paying my respects to your elders, past, present, and emerging. In terms of housekeeping, as this is an interactive webinar, there are walkthrough and exercises littered throughout for you to turn your mind to. There will also be viewer polls. With these, you will need to exit full screen mode to submit your responses. Additionally, questions can be asked at any time during the webinar by typing into the chat box below. As I believe Confucius once said, the man who asks a question is a fool for a minute, but the man who does not ask is a fool for life. Depending on timing though, I will look to answer them at the end of today's webinar. So that's the administrative stuff done. Let's get on with why you are here, and that is to refresh yourself about what your duties are as responsible persons of your organizations and get ideas on how to manage them. With this in mind, and to overview today's session, we will touch on the ACNC framework briefly to see how it all fits together. We will wade into some of the issues around the responsible persons, in particular suitability issues. We'll then dive a little bit deeper to take a closer look at the duties under the ACNC Act, and then look briefly at the duties and responsibilities that come up elsewhere. And then finally, we'll wrap things up with some practical tips and tricks, which you can take home with you. So let's have a look at the ACNC framework. Now, back in the day, the not-for-profit sector was mainly regulated by the ATO and ASIC. However, other regulators and government departments could get involved depending on the organization's size and type. Given the myriad of possibilities there was a lot of confusion rampant in a sector which was, at least in 2012 and 13, larger than both the communications and utilities sectors combined. As such, the government decided to try and centralize everything, which culminated in what we know today as the Australian Charities and Not-for-Profits Commission Act 2012, or the ACNC Act. As a general proposition, the ACNC Act establishes a regulatory system for the not-for-profit sector. As a fundamental part of the system, charities are now required to register and will need to comply with certain obligations, including minimum governance and external conduct standards. These are what are called the ACNC governance standards. As a side note, and as some of you are probably already aware, the Corporations Act codifies certain duties and imposes these on company directors and officers. As part of streamlining things, some of these duties were switched off. But going back to topic, there are 6 standards that you need to be aware of, namely Standard 1, a charity must be not-for-profit and work towards its charitable purpose. Standard 2, a charity must take reasonable steps to be accountable to its members and provide adequate opportunity for them to raise concerns about governance issues. Standard 3, a charity must not commit a serious offence under any Australian law or breach any law that may result in a penalty of 60 penalty units or more, or I guess $13,000 or so if the offence was committed after 1 June 2020. Standard 4, a charity must take reasonable steps to be satisfied that its responsible persons are not disqualified and remove them if they are. Standard 5, a charity must take reasonable steps to make sure that its responsible persons understand and carry out the duties set out in the standard. And finally, Standard 6, which is something that came about earlier this year. A charity must act in a way that maintains and enhances public trust and confidence in the not-for-profit sector, which typically entails taking steps to ensure that the charity can be accountable for past conduct and becomes a participating non-government institution under the National Redress Scheme. Today's focus, of course, is on Standards 4 and 5. Okay, so generally, Standard 4 revolves around the charity taking reasonable steps to ensure that responsible persons are not disqualified from either managing a company or being on the charity's board. What's important is that we know who are responsible persons and what steps need to be taken. So let's focus on who are responsible persons. Generally, as it says on the screen, these are the people who are responsible for governing a charity. Now, spot quiz. On the list, who would you consider to be a responsible person? I'll give you a minute or so. So there's about 8 or 9 of them there, and all of them are typically members or quite important in decisions of the charity. And the winner is potentially all of them. What's important in determining whether or not a person is a responsible person is to see if they have any right or responsibility in making decisions for the charity. I might use an example here. Let's say we have a CEO who is responsible for managing the day-to-day operations of the charity, but is not formally a director. If the CEO simply reports to and takes instructions from the board, then obviously the CEO will not be considered a responsible person. However, if the CEO tends to lead the board discussions and the directors typically just fall in line, then there is an argument that the CEO may be a responsible person, and to draw parallels to the corporate world, could be described as a shadow director of sorts. Okay, so the next part of this issue is to consider what steps are being taken to ensure that responsible persons are not disqualified and to remove them if they are. Generally, a person could be disqualified if they have been convicted of certain offences, such as a serious offence that involves decisions affecting the whole or a substantial part of the business of a corporation, or an offence involving dishonesty that is punishable by 3 months prison or more. They can also be disqualified if the person is an undischarged bankrupt or are otherwise disqualified by the court or regulators. Just a reminder that the onus is on the charity and not the individual involved. In terms of what you as a charity need to be doing, the usual things are to do searches of the ACNC Disqualified Persons Register and the ACNC Register of Disqualified Persons, as well as ask the individual involved to sign a declaration confirming that 1, they understand what it means to be disqualified, and number 2, that they are not disqualified. This in itself is fairly straightforward, but let me know if you need a link to the registers or need a template declaration to work with. One thing to remember though is that Governance Standard 4 is a continuing obligation, and that whilst you've done your searches and got a declaration from the beginning, you may need to take steps to remove a person if they subsequently become disqualified. Okay. So let's move on and talk about directors' duties. As mentioned before, company directors owe various duties under the Common Law and the Corporations Act. However, as part of streamlining things, the ACNC Act effectively switches off some of the provisions under the Corporations Act that relate to directors' duties and instead imposes its own version of things. There are a few things to remember about all of this. First is that the provisions under the Corporations Act that give rise to criminal offences are not switched off. I will talk more about this a little bit later. The second thing is that the standards are owed by the charity and not the responsible person involved, meaning the focus is always on the charity's actions. Okay, so let's have a look at the standard itself. As you can probably see, Governance Standard 5 is made up of 6 parts, namely the duty to act with reasonable care and diligence, the duty to act in the best interests of your charity and for a proper purpose, the duty not to improperly use information or your position, the duty to manage financial affairs responsibly, the duty to disclose and to manage conflicts of interest, and finally, the duty not to allow a charity to operate whilst insolvent. Let's dig a little bit deeper. For those who have come from the corporate world, the duty to act with reasonable care and diligence is very similar to the statutory duty to exercise the same degree of care and diligence that a reasonable person would if they were a director of the company and occupy the same office and had the same responsibilities. There are a few things here though. Firstly, what is reasonable? Whilst there is no definitive guide on this, as a general rule, responsible persons are required to exercise the same degree of care and diligence that a reasonable person would in the circumstances. And following on from this, what qualities does a reasonable person have? Once again, there is no real definitive guide, but the general expectation is that responsible persons should be in a position to guide and monitor company management and know how to read financial statements. I might use an example here to add some color and to test out the polling functions a little bit. So William is an experienced property developer and on the board of a charity. He has been told by his real estate agent buddy that there is some cheap land that may be suitable for a building, SIL premises, that is coming up for sale as part of the liquidation process of another company. The friend has urged William to act quickly. Hearing all of this, William immediately proposes to his own board and the charity that the charity purchase the land. The other directors rely on William's expertise and approve the proposal without conducting any due diligence whatsoever or having a look at their own finances. After signing the contract, the charity realizes that it cannot afford to buy the land, and the land itself cannot be used to build SIL premises. Now, the question is, have the directors satisfied their duty of care? I'll give you a moment to have a think about things before you select what you think is the answer. Just a reminder that you need to exit full screen mode to submit your answer. So there are 4 options there, and they're split up really between what you think the board should have done and what William should have done. Okay, so the results I think are in, and most of you have answered no. None of them have done their job properly. I would tend to agree with you, as I don't feel that William or the board have really done enough, as I would expect a reasonable person to do at least some basic due diligence and confirm that whether or not they can actually sign the contract and can afford to buy the property. The board could argue, of course, that they did what they could within the time and knowledge constraints. However, we will talk about this in greater detail later on when we talk about the business judgment rule and the information protections. Okay, so moving on, the duty to act in the best interests of your charity and for a proper purpose. To draw correlations from the corporate world again, this is very similar to the statutory duty to exercise powers and discharge duties in good faith in the best interests of a company. There are a few elements here. Firstly, to act honestly and fairly essentially requires a responsible person to ask themselves if they honestly believe they are acting in the best interest of the company, or to take a slightly different approach, would any reasonable person believe the activity to be in the best interest of the charity and is to further its charitable purposes? To answer these questions, of course, a responsible person would need to understand what the charity's purpose and objects are, as well as what is being proposed. The second part of all of this is whether a responsible person is acting in the best interest of the charity. This raises the question of conflicts of interest, as from a philosophical point of view, a responsible person should be trying to put the charity's interests above their own personal interests. This can be quite difficult, which makes disclosure and proper minuting quite important. I might use another example here. Jerry owns a business which provides paramedic services. Jerry is also a director of a not-for-profit hospital. At the hospital's board meeting, it's proposed that the hospital buy new ambulance vehicles and employ more paramedics. What should Jerry do I'll give you a moment to have a think about things. Reminder again, you will need to exit full screen mode in order to submit your responses. Once again, we have 4 options here. First is to simply not disclose and vote against any resolution to buy new vehicles and employ new paramedics. Second option is to not disclose and participate in discussions. Third option is to disclose and to participate in discussions anyway. And the fourth is to disclose and leave the room. Now I think we have the results. This is quite close. We have 2 fairly close responses, C and D. In my view, the ideal thing for Jerry to do is to disclose his personal interests and then leave the room so that the board can decide what to do next. While this would not be in the best interest of his own business and may not be ideal for the hospital board, failing to recognize the conflict and managing it appropriately may instead be a breach of the duty. Practically speaking, though, the board could decide that it is in the best interest of the charity to let Jerry participate considering his experience in the area, but require him to abstain from voting. However, this is a call for the board to take, not Jerry. Okay, moving on. The next duty is the duty not to improperly use your position or information. This bears great resemblance to the statutory duty on officers and employees not to improperly use their position or improperly use information to gain an advantage for themselves or someone else, or to cause detriment to the charity. As you can see here, there are a few things to note. First is that there needs to be some misuse, or in other words, some intent to receive personal gain or to cause damage. Second, on the issue of position, a position must be used in a way which is inconsistent with a proper discharge of obligations or responsibilities. Now, what is proper is a little bit fuzzy, but the idea here is really to try and look at things objectively to determine what a reasonable person would be doing with the same knowledge and in the same circumstances. And finally, with information, the information needs to have been acquired as a result of being involved with the charity. The information itself does not actually need to be confidential to fall under this hat. Now let's try a walkthrough exercise. Steve is a board member of a not-for-profit housing provider. It is also an employee for a commercial property developer. Steve is asked by the charity to prepare a response to a tender for a new government housing contract. Now, which scenarios would lead to a breach of duty? Let's work on this together. First statement is that Steve proceeds to prepare the tender on behalf of the charity. Well, this sounds okay with a few caveats. Of course, Steve's employer probably won't like this. Second statement, Steve participates in his employer's bid for the tender contract. From the charity's point of view, probably not great, especially if he knows or has received information from the charity, whether or not it is confidential, that may be relevant to Steve's employer and his own bid. Next statement, Steve discloses to the charity his employer's intentions to also participate in the tender. Now, theoretically, yes, this makes sense, and it may also make sense for Steve to disclose his involvement with the charity to his board, to his employer as well. The final statement, Steve discloses to the charity that he cannot prepare the tender because he knows his employer will also be bidding. This makes logical sense to avoid any conflicts of interest. And I guess from the employer's side, it may be appropriate for Steve to suggest to his employer that he be taken off the project team as well. Okay, so the next duty is to disclose and manage conflicts of interest. This links in closely with the previous duties, and disclosure is typically seen as a very important risk management tool. Conceptually, the duty covers two types of conflicts: actual conflicts, which where a responsible person is likely to gain a personal advantage for themselves or a relative or a close friend because of their role in the group. And second, perceived conflicts, which is where others may reasonably perceive there to be a conflict, and that perception creates a risk. A further type that you may want to consider disclosing are potential conflicts, where a particular set of circumstances gives rise to a conflict but doesn't actually present an actual conflict right now. When there is a conflict, it is really up to the rest of the board or the management group to decide what to do about it. So in the example of with Jerry before in his not-for-profit hospital, the board could have decided to let Jerry participate in the discussions but abstain from voting, but that again is a decision for the board to make, not Jerry. Now the next duty is about managing the financial affairs responsibly and is linked closely to the duty to act with reasonable care and diligence. Given that the charities are meant to be not-for-profit in nature and are usually reliant on donations and public funding, this can be quite important. Whilst there are no benchmarked or mandate approaches about this, the key is to take reasonable steps, which may involve meeting ACNC financial reporting requirements and setting up financial controls, such as putting together a business plan or budget and tracking performance, providing the board with regular balance sheet updates, and managing how charity funds are accessed and used. Once again, it is important that responsible persons are able to read financial reports and do so. Whilst there may be greater expectations on a treasurer or CFO, as well as on members who are more financially literate than others, especially in relation to picking up financial issues, the bottom line is that all members of the board committee are expected to be up to speed with things. Okay, question for you. What can you actually do with charity funds? On the screen, you'll see a few statements here. Which of these are false? I might give you a second or so just to take things in. Right, a charity can't make a surplus or a profit. This technically is not correct, as whilst a charity should not be aiming to make a profit because of its not-for-profit nature, there is no actual prohibition against making one. Second statement, charity can't keep money in reserve. Once again, incorrect. In fact, yes, if there was no safety net or rainy day fund in place, I would be asking myself if the duty to manage financial affairs properly was being complied with. Next statement, a charity can't invest its funds. Not correct, in the sense that charities can invest if what it is investing in aligns with the charity's objects. Next statement, charity can't undertake commercial activities. Again, not correct, as commercial activities can be undertaken as long as they align with the charity's objects. And finally, a charity can't spend on internal administration. This is definitely wrong, as at the very least, you will need to spend money on putting together the financial statements and reporting back to the ACNC. So just to recap, all of these statements are false. The last duty that we have is the duty not to allow a charity to operate whilst insolvent. This is quite closely linked with the duty to manage the financial affairs of the charity responsibly, and it's very similar to the Corporations Act duty to not trade whilst insolvent. As a general concept, being solvent means that you can pay your debts as and when they fall due. To meet this duty, charities are expected to keep up to date in relation to its debts and cash flows, take steps to prevent incurring debts that cannot be repaid, and identify and look for ways to control expenses and liabilities and to manage cash flows. As practice, which of the following are signs that a charity is insolvent? I'll give you a few seconds to have a think about things. Okay, realistically, all of these are telltale signs that the charity may be in trouble. So we've been through all 6 duties, and as you can see, a lot of them are interlinked. So the question is what to do about them. Well, the ACNC Act provides some guidance in the form of protections, namely Protection 1, the reliance on information. Number 2, the business judgment rule. Number 3, that there are reasonable grounds to expect solvency. And number 4, in relation to an individual, that some illness or other reason has prevented them from participating in management. So, Protection 1 applies if the entity relies on information in good faith after making an independent assessment of that information. The information must have come from a reliable and competent source, such as an employee who is working in the field or a professional advisor or expert in the area. So if we were to take us back to the previous example with William, the experienced property developer and his charity, the board could argue that the protection applies in relation to identifying property, as they got this information from William and his real estate agent friend. Now, Protection 2 is more commonly known as the business judgment rule and is very similar to the business judgment rule under corporate law. Generally, a responsible person will be taken to have acted with reasonable care and diligence if the decision was made in good faith for a proper purpose. The responsible person did not have a material personal interest in the subject matter of the decision. The responsible person has informed themselves about the subject matter of the decision to the extent they reasonably believed appropriate, and the responsible person rationally believed that the decision was in the best interest of the registered entity. Extending and applying this to the charity, in order to try and come under this protection, becomes important to make sure that conflicts of interest are properly disclosed and that proper minutes of the decision-making process are taken. The next protection is that there were reasonable grounds to expect that after everything has happened, that charity would remain solvent. This goes hand in hand with the duty not to allow the charity to operate whilst insolvent, as well as the duty to manage financial affairs responsibly. What is important here is the board or the management committee have actively turned their minds to the issue of solvency and are taking steps to manage or prevent any potential insolvency. Once again, good minuting becomes important. And the last protection covers situations where a responsible person has not been able to do their job due to illness or some other reason. If, despite everything, there is a determination that there has been non-compliance, there are a few potential consequences to be aware of, including the revocation of the charity's charitable status, the suspension or disqualification of the responsible person involved, as well as administrative penalties. Now, all of this can be and will be published on the ACNC website, which can be a hit on PR. So that's everything under the ACNC Act. We will now have a quick look at the duties elsewhere, which includes duties at common law, personal responsibilities for tax, and duties under the Corporations Act and under incorporate association legislation. Right, so common law. As I mentioned before, the ACNC Act only turns off certain duties under the Corporations Act. It does not actually turn off the common law duties, which include the duty to act with care and diligence, the duty to act in good faith and for proper purpose, the duty not to misuse information or positions, the duty to avoid conflicts of interest, and the duty not to fetter discretions. Now, these all bear great resemblance to the ACNC Act equivalents. As such, I will not go into these duties in any great detail. Moving on, and in terms of the Corporations Act, and as I said before, whilst the main duties are turned off, the duties attaching to criminal offences still apply. These duties predominantly relate to situations where a director has acted recklessly or dishonestly in failing to discharge the duties, or are otherwise involved in breaching the duties to prevent insolvent training. On the flip side, however, the safe harbour provisions under the Corporations Act may also still apply. Essentially, the safe harbour provisions allow some breathing space for directors to explore and pursue turnaround options and take reasonable steps without the threat of an insolvent trading claim hanging over their heads. Now, certain conditions do need to be met, including that all employee entitlements have been paid, all tax reporting obligations have been met, and that the charity is not in administration or liquidation already. Now, there are also some limitations around what is covered, such as that it relates to developing and taking some course of action that is reasonably likely to lead to a better outcome for the charity. Now, moving on to tax laws. Directors of charitable companies can become personally responsible for a charity's PAYG withholding, superannuation guarantee charges, GST, and payroll tax obligations under what is called the Directors' Penalty Notice Regime, or DPN regime. This in itself is relatively straightforward and involves the ATO issuing notices to directors in relation to the company's outstanding tax obligations and taking action against the director personally. And I guess finally, assuming that your organization is an incorporated association rather than company, the relevant incorporated association legislation will also impose certain duties or responsibilities on its committee members. Okay, and finally, let's have a look at some practical tips and tricks that will help you manage your duties. Now, the first one is to put in place a robust induction process, which includes instructions on the duties of responsible persons. The second thing you can do is make sure that responsible persons are provided with appropriate governance documentation to ensure that they have a thorough understanding of what their duties and responsibilities are. Next, you can also put in place policies around conflicts of interest and related party transactions. You can also put together a register to detail all professional development courses and training attended by responsible persons and try to encourage them to undertake appropriate courses. Also, you can also establish a board charter and a code of conduct. You can also take steps to ensure that all responsible persons have signed a document which sets out their role and their obligations to the charity, and have them make all disclosures in writing. Finally, you can also minute and document all decisions and ensure that both electronic and hard copies, corporate registers, are properly maintained. From a director or responsible person's point of view, it may also be appropriate to consider putting in place a deed of access indemnity insurance and ask the charity to take out D&O insurance in relation to your involvement in the organization. Okay. So that's the end of the main part of this webinar. Let's see if there are any questions. Okay, so the first question that we've got here is, what does directors' insurance actually cover? Now, D&O, or directors and officers insurance, typically covers activities that the director has undertaken where they are doing it as part of the charity. In some circumstances, a disgruntled party may try and take action against the director personally for whatever reason, rather than going against the charity, because they feel that the director has made certain representations. At the end of the day, that sort of activity would be covered by D&O insurance. Okay. Another question has popped through. Could I be responsible for contracts that were signed before I was a director? I'm assuming this relates to the question of managing financial affairs property. Now, theoretically, yes, you can still be responsible for contracts that were signed before you were a director. Now, the question for the directors at the time the contracts were signed will be, of course, to work out whether signing that contract was in the best interest of the charity, and to determine whether doing so would potentially render the charity insolvent. Now, fast forwarding it for a new director, the director would have to be aware of and be alive to the issues at hand with that particular contract, and work out exactly whether it would be financially feasible to continue with that contract. But there are, I guess, limitations to their responsibility. They, I guess, from the director's point of view, they could be looking and seeing if there is a means of trying to get out of that particular contract, or to try and renegotiate something with that contract. The next question is, what is a deed of access indemnity insurance? Now, a deed of access indemnity insurance is a deed which entitles a director to gain access to corporate registers and documentation for the period they were a director, to gain the benefit of any indemnity that the charity can offer in relation to the director or the responsible person's actions as a director or responsible person, and to ensure that the person gets the benefit of any insurance or D&O insurance taken out in relation to the board. Okay, next question that we have is, with acting for proper purposes, how do you resolve situations where there are multiple purposes? Now, this question, and this is probably a really practical question, especially since when you decide things, you'll be considering a number of different reasons and purposes, and some of these may involve situations of conflict. So you may have situations where an action or an activity aligns with the charity's main purposes, but will also benefit or potentially benefit a director or responsible person involved. Now, to try and resolve this, you really have to look and see what the main purpose was, and consider if there wasn't the improper purpose or the other purposes, would you still have undertaken that activity anyway? I think we have a little bit of time left. Might give a minute or so just to see whether there are any other questions, but otherwise. Okay, so I guess we don't really have any other questions. So thank you again for tuning in. Once you, oh wait. I think we have a question coming through. Okay. So in relation to protection 1, reliance on information, what steps should board members take to be able to rely on the protection? As in, can they rely on what they were told verbally, or should they investigate further, even if the advice was provided by an expert? Okay, that's a pretty good question, and probably quite relevant for a lot of boards that want to take ad hoc advice. Now, realistically, the board members should be trying to ascertain or dig a little bit deeper, or even ask that expert to commit that advice in writing. If that person is not willing to do that, then the only real solution is for the board to take a note of it, either send an email off to the expert confirming what they've been told, and or minute it in their board minutes if it's something that comes up during board discussions. Is there a standard template for directors online which can be used? I'm not entirely sure what template you're referring to, but I guess if you're asking about a template for directors to confirm or warrant that they understand their duties and confirm that they are not disqualified, then yes, there is a pro forma, I think, that is available on the ACNC website. But I guess if that's not suitable, happy to put one together and circulate it to you. Okay. Next question is, the ACNC differentiate between responsible and authorized persons. We deem CEO as an authorized person, is that correct? So the authorized person is really the person that is the main contact point for the charity and for the ACNC. Typically, yes, the CEO can be an authorized person, but this is really from an administrative point of view, and it is someone that you nominate on the when you complete the forms on the ACNC register to let them know. So I guess there is a difference between a responsible person and an authorized person. And to answer your question specifically, the CEO shouldn't really be deemed to be an authorized person unless the form that is completed and returned to ACNC suggests that they are. In some circumstances, I have seen that the authorized person is not the CEO, but the company secretary. So I guess from that point of view, because the authorized person is really just the contact point for the ACNC, it may or may not make sense for the CEO to be that person. Okay, I don't think there are any other questions. So once again, thank you for tuning in. Once you leave this webinar, you will be asked to complete a short survey on today's presentation and have the opportunity to provide some feedback. You should also receive a follow-up email within the next 24 hours or so with a link to a recording of today's webinar, along with the handouts. Do let us know though if you don't get any of these. So on behalf of Bartier Perry, thank you again for joining us today and enjoy the rest of your day. Thank you.